is very, very confusing even to attorneys practicing in this field. As a starting point, it prohibits people who have a conviction from any court that had a potential sentence of a year or more, but there are a bunch of additions and a bunch of exceptions to this rule. Some felony convictions don't prohibit a person from possessing a firearm, even if you served a jail sentence. For example, most white-collar business crimes don't count, so people who rip off millions in pension funds or commit some kind of security fraud can still go out and own their 25,000 shotguns and go grouse hunting. And I know I'm kind of cynical about that. And, you know, it may be that there are a lot of perfectly nice people out there who happen to have these white-collar convictions. But the federal gun control law has got a lot of classist and racist overtones, and this is one of them that is one of my pet peeves. You know, you rip off a lawn ornament as a kid on an over-boisterous night, and you get threatened with federal prison if you try to buy a new deer rifle, but commit a white-collar crime, you know, that impacts hundreds of working people, and, you know, hey, no problem, the gun control laws don't apply to you. That's just one of the real injustices in how these laws are applied. Other felony convictions that don't count include ones where someone's gotten a pardon, or if you had a deferred sentence, which results in the conviction later being set aside, or if you live in a state where some of your rights were taken away when you were convicted. In many states, if you get convicted of a felony, you lose the right to vote or to serve in office. But then when you get off probation or sometime later that right is reinstated, then the conviction no longer counts for federal firearms prohibitions. But, for example, get convicted of the same thing in Vermont, we don't take away any of your rights on conviction, so the same conviction for the same crime would count for the rest of your life, which is both ironic and very confusing, because the same conviction for the same crime in different states may or may not count to prohibit you under federal gun control law. One last irony on that is that many state misdemeanors also count to disqualify people under the same federal category. If the state misdemeanor has a potential jail sentence of 2 years or more, the federal gun control statute counts it, even though it was a misdemeanor, and that includes a lot of state DUI and minor assault-type convictions. So just on that one category, there's tons of confusion as to what counts and what doesn't. The other three criminal-related categories are, the second one is misdemeanor convictions of domestic violence, which continues to take a lot of people by surprise because, you know, minor disputes that were treated, you know, as very minor incidents decades ago are suddenly popping up and causing Brady denials. Another related category that's not criminal but has to do with court orders is pending family court stay-away orders. And those can cause a lot of trouble because a lot of times the court records don't note when the stay-away order has closed and you're reinstated to your firearms rights. And the last one is fugitive from justice, which is if you've got a warrant out for you somewhere, even for an unpaid civil traffic ticket you got on vacation and forgot to pay, not that I've ever done such a thing, leaves you being a fugitive from justice, and you'll get a Brady denial on that too. So the four, at least court records-related categories are felony convictions, misdemeanor domestic assault convictions, family court stay-away orders, and fugitive from justice. And they all have to do with court records that are often confusing or inaccurate, especially older records in rural states like Vermont here and in many other rural states. Even up till very recently, they were all kept handwritten on little index cards that are unreadable that now people are trying to load into these databases, and a lot of mistakes can be made on them.
Well, it certainly is confusing.
Yep.
So I guess what you're telling me is if only 4 of the 9 categories had to do with court records, I take it the other 5 have nothing to do with criminal convictions.
Absolutely. And these other 5 non-court-related categories that you can be prohibited from having a gun for really take a lot of gun owners by surprise. I think most folks assume that the people who are prohibited from having guns are criminals, but 5 of these categories have nothing whatsoever to do with criminal courts. 3 of those are having a dishonorable discharge from the military, being an illegal alien, or renouncing your U.S. citizenship, although that's one of the least utilized denial bases, and it's a little unclear exactly how far you'd have to go or what exactly you'd have to do to qualify under that one. But two of these other non-criminal categories that are very troubling is one is called being a known user of illegal drugs. And this doesn't require any criminal conviction or proof of any kind. It relies on the opinion of your local law enforcement officers. And I've talked to at least two guys who had called to consult with me who got Brady denials with no criminal record. And both of these guys had ponytails and Harley Davidsons, and their local police had assumed they were pot smokers and inserted into the database regarding names checks for background checks that they were known drug users, even with no criminal convictions whatsoever. And the only relief these guys would have had would have been filing a federal lawsuit to try to rectify the situation. Where they then, with no criminal conviction, would have been in the position of trying to prove that they were not users of illegal drugs. And another non-criminal category is people who've been adjudicated mentally incompetent, and this is also a very troubling category. I know about a year and a half ago now, 2 years ago, the Veterans Administration uploaded thousands of records of primarily Vietnam-era vets into the Brady background check databases. And the suspicion that folks have now is that military discharges on the grounds of mental health issues are going to start being used as grounds for Brady denial as being adjudications of mental incompetence. This really hasn't started to play out yet, but it's extremely troubling, and it's going to raise all kinds of issues about the privacy of mental health records and just how far the government's going to go in disarming people who might have sought mental health counseling for temporary problems like depression associated with job loss or something like that. So these 5 categories have nothing to do with criminal convictions at all, and you got to know that under the Federal Gun Control Act and under Brady, many people without a single criminal conviction are being disarmed by federal gun control.
Okay, well, I like to ask authors why they write their books. So tell us why there's a book about Brady denials.
Well, every year, of the 100,000 people who get a Brady denial or so, many of them are simple mistakes and should be promptly overturned. Many of them that aren't simple mistakes, that are based on actual incidents, if you actually looked into the facts and the details of those incidents, it's also an error, and the Brady denial should be overturned. And of those that are accurate, that is for people who actually do have an incident that meets one of these 9 categories in their past, there are lots of ways for people to go back and try to remove those things from their records or change them, but most people don't pursue these options. And the reason they don't, of the small percentage of people who do, the rate of overturning these is pretty good, but only a small percentage of people pursue that option. And I think most people are afraid of either bringing more attention to themselves or raising red flags to government law enforcement agencies. And I can understand that on many levels, but it's really just not right. Just like getting a denial of coverage from a health insurance company, and a lot of people don't challenge it, even though they're entitled to get the coverage. It's the same thing. You have a right. You have a right to your firearms rights. You have a right to have your firearms, constitutional right. Getting the denial, it's very troubling that so many people just accept them at face value, thinking, gee, well, the government says so, so they must be right. Thousands of American citizens are just accepting being disarmed when they don't have to be. So I wrote this book, Brady Denial. You can get your guns back. It's available from Paladin Press. Can I go ahead and give them that number right
Oh, absolutely.
Okay. They can. You can find the book, Brady Denial. You can get your guns back.